Well, good evening to everyone in Latin America and good morning to our guests in China and Japan. My name is Carlos Esguerra. I'm the chair of the International Committee of the Colombian Competition Law Association. For us, it's a privilege to start this new and exciting project. The aim of this project is to conduct a series of interviews with competition law experts around the world to discuss about hot topics of competition law and their implications for businesses and law practitioners in Colombia and Latin America. The first project and the first interview that we want to conduct is the implementation of compliance programs in China and Japan. The influence and participation of Japanese and Chinese companies in Latin America is not new, but it's certainly increasing. I believe everyone from business people to lawyers have experienced this increasing wave of all sorts of business and products coming from the other end of the world, which offers new perspectives, angles, and options on how to do business, and of course also impacts the way we understand and practice law. And of course, competition law is not the exception. Probably the clear example of this is how compliance programs implemented in China and Japan can impact businesses in Colombia and Latin America, and how competition lawyers should adapt to those trends. And to discuss that, we have two very special guests. First, Michio Suzuki, partner at Baker McKenzie in Japan. It's an honor to have you here, Michio. And
thank you.
Laura Liu, senior associate at Baker McKenzie in Beijing. Welcome, Laura. Thank you for being here. Likewise, we're also very glad to have Carolina Pardo and Angélica Navarro from Baker McKenzie local team, who will be conducting the interview. With that introduction, I don't have anything else to say. So thank you everyone for being here, and Carolina and Angélica, the floor is yours.
Thank you very much, Carlos, and thank you, Laura and Michio, for joining us, and Angélica as well. As you mentioned, Laura is a senior counsel with the Baker McKenzie Antitrust and Competition Practice Group at Baker McKenzie Fenshun Joint Operation Platform in China. And also Michio is a partner in the competition and corporate groups in the Tokyo office of Baker McKenzie. So welcome everyone, and please excuse that we are doing these interviews in English. We know that we are focusing our target in Latin America and particularly in Colombia, but given our special guests, we will be conducting these interviews in English. So before we were discussing that, as Carlos was introducing, the programs and the influence of the Asian companies is not new in Latin America, but its importance is increasing. And therefore, we thought it would be of great interest for everyone to consider what is going on in these latitudes, and as also to understand a little bit more about the compliance issues that companies in China and in Japan are facing. So with that, I'm going to ask Laura to give us a very quick overview on the trends and compliance programs in China.
Thank you. I'm very happy to be here and to join the discussion. So compliance is not something new in China, but antitrust compliance, I think, have just been come into the focus of the business operators in China just in recent years. And this is because that I think since 2018, the China central government started to initiate a campaign for encouraging the companies in China to pay attention on compliance programs, including antitrust. And the China central government has published kind of guidelines to help business operators, including the Chinese SOEs, state-owned enterprises, with how to set up a kind of robust compliance program within the organization. And following this advocacy, in September last year, China's competition authority, what we call the SAMR, published the very first anti-monopoly compliance guidelines for companies in China. This guideline indeed provides a framework for how business operators should establish an antitrust compliance system and manage antitrust compliance risks in China. This antitrust guideline is not mandatory, but it is a very important indicative of the key aspects that the China Competition Authority would expect to see in a good compliance program. And we have seen the trend that after the publish of this compliance guideline, a lot of companies operating in China, including the multinational companies, state-owned enterprises, as well as private companies, they moved very quickly to help them to adopt this big change and to start to set up their own antitrust compliance programs within their respective organizations. And also a very important development is that I think also in the same month, in September last year, the China Competition Authority issued a draft guidelines focusing on the Chinese companies' overseas business. This is a specific guidelines for the antitrust compliance for the Chinese companies to help them to avoid the antitrust risk in overseas markets, except for China. So that's a very, I would say, a very interesting development. This overseas compliance guidelines still a draft until today, but I think it played a key role for the Chinese companies, both the SOEs and the private companies, to focus their antitrust compliance requirement to be compatible with the local competition laws across the world. So that's, I think, the most general overview of the trends and the development in China in respect of antitrust compliance.
Thank you very much, Laura, and certainly very interesting to see that even though at a preliminary stage in a draft, the Chinese government is seeking the Chinese companies with overseas operations to ensure compliance with overseas antitrust and competition laws. That will certainly increment the consultations that Chinese companies make of how competition laws work in Latin America for those companies that want to do business in these jurisdictions. So Michio, I'm going to turn now to you. And first of all, thank you for your participation once again. And also ask you, what are the trends? And similar to what we asked Laura, what are you seeing is happening in Japan in terms of promoting competition law compliance in your country?
Thank you very much for the introduction, Carlos and Carolina. My great pleasure to be here to join this exciting session with you all. Muchas gracias, todos. And well, in Japan, the situation is more like similar to that in China, I guess. The Japanese Competition Authority, which is the Japan Fair Trade Commission, or JFTC, I'm calling it onward, has been keen on promoting competition compliance. The difference with China may be that the JFTC has not published any particular guidance to how the compliance program should look like. I think the general understanding of the Japanese companies and Japanese practitioners of competition law is that the compliance program, if any, should look like the global standard, like we see in the European Union or companies in Europe or in the United States. So I think the JFTC's intention is to keep proactive enforcement against the competition law infringement, and thereby expect business operators in Japan to become more aware of the importance of the competition law compliance, and that should include a compliance program. So I think this is a kind of indirect way to promote competition law compliance program in Japan. And actually, we have seen many clients who are willing to proactively introduce a competition law compliance program. And we very regularly have assignments from the clients regarding the introduction and implementation of the compliance program.
Thank you very much, Michio. And that's a very swift way of perhaps going into our next topic. And that has to do with what are the credits, if any, that a company that is located in China or in Japan would receive during the course of an investigation for competition matters for having a sound compliance program. So I don't know, Laura, if I can start with you, asking you to comment about any credit or any benefits that a company in China would receive from the SAMR for having a compliance program.
Thank you. This is I would say this is a very interesting question, and normally we will, being asked these questions by our clients, especially for the multinational companies who have business in China. Unlike some other jurisdictions, for example, the US, in China, there's no clear rules or provisions that indicating that the company can be can be get benefit or can be granted with any credit for the antitrust compliance program being existing. There's a long debate within the authority because some comments indicating that if the company indeed with a very good competition compliance program, then why these violations will come up? So that's the issue. So we actually have seen during the consulting process with the antitrust compliance guidelines, well, our firm has also been invited by the authority to provide comments from an international law firm perspective. But the final version is still silent on this point. I think that this actually clearly show that the China Competition Authority, they will not actually, provide any clear provision that mentioning that the companies will definitely, be granted credit based on the existing antitrust compliance program, or based on this argument. That being said, in practice, based on our own experience of handling some kind of investigations in China, if the company with a compliance program that covering some kind of antitrust element here, the antitrust compliance program, this could be a helpful argument or helpful, to negotiate with the authority for kind of negotiating the volume of the penalty, the monitoring fines. But this, though it can be a good reference, but not, I would say, a kind of not a hard argument or a very, helpful arguments that will definitely help the companies to get penalties. That's, I would say, the something happened in practice. Another interesting point I would like to mention is that we can see in some very recent antitrust cases, including both merger controls and antitrust investigations, or for example, abuse of dominance, that actually the China Competition Authority, they record the parties being investigated to to commit and to set up a competition compliance program within the organizations as a kind of remedies and something affiliated with the penalty decisions. I will stop there.
Thank you, Laura, very much. And that's very interesting. So what I hear from what you're saying is that there are no credits as such, but as you have explained, compliance programs have been implemented and requested to companies as part of the remedies, as you have explained, during investigations. That is very, very interesting. What about Japan, Michio? What are you seeing from the JFTC?
Well, the situation is again similar to China, because the JFTC has not given any clear guidance to how the existing compliance program should be credited in case of investigation. I think the JFTC's focus on compliance program should be more on the post-investigation side. So as part of a kind of like Laura said, a kind of remedy in that the company proposes or the authority requests. We very often see the introduction of compliance program with focus on competition law. And well, in the meantime, the JFTC has some discretion to determine the value of fine. So existing compliance program may be positively considered within such discretion. And I would like to point out one particular comment on the so-called commitment procedure in Japan. This is kind of a more relaxed or lenient way of enforcement that applies to kind of less important infringements. So this does not apply to hardcore cartels, but within this commitment procedure, an alleged party proactively proposed a plan to seize the infringement and secure compliance onward. So compliance program is an essential part of the commitment in such event.
Thank you, Michio. So what I hear is that although there are no clear guidelines, both authorities would consider giving some sort of benefits, although it's difficult to anticipate what would be the weight of such benefits during an investigation, as there are no clear guidelines in that regard. But I also understand from what you're saying is that as part of the termination of an investigation, and perhaps also as a remedial action, it is highly possible that the authorities will continue to request companies that have been found to be in breach of antitrust provisions that they do implement specific measures with respect to antitrust compliance. And that seems to be a trend based on what you are both mentioning, and that is clearly very interesting because that means that the remedial actions would impose that the future behavior of a company is not just paying a fine, but is committing to specific mandatory actions that go into the culture of the company. So that is certainly very interesting. I am going to turn now to my colleague, Angélica Navarro, who is an associate. She's a senior associate at Baker McKenzie, Colombia. She has been with the firm for some years now, but she used to be an advisor to the Superintendent of Industry and Commerce, and she has a wealth of experience in competition matters. So Angie, thank you. And I will leave for you to make the next question to our special guest.
Thank you very much for that generous introduction. And thank you, Michio and Laura, for sharing your experience and views in this interesting matter, and the Colombian Competition Association for this marvelous invitation. So continuing on the standard in terms of compliance programs for the private and the public sector, we would like to know the difference, if there is any, between the obligations to implement compliance programs for state-owned enterprises and private enterprises. Maybe you can start, Michio, by telling us if you have any experiences on any standard difference in this standard in Japan.
Well, you know, all or most, at least most of the businesses that used to be operated by the public or state-owned enterprises have been privatized in Japan. So I don't think in Japan right now we have any distinction between private and public, I mean, private and state-owned companies.
That is very interesting, considering the what has been going on the privatization in Japan on these enterprises. Thank you. And Laura, do you have any thoughts or any input on this matter regarding the standard in terms of compliance programs for public and the private sector?
Yeah, that's a very, I mean, that's a very relevant question for China, because, you know, in our country, SOEs are very, I would say, the important and the key economic business operators in China. And they are also the ones who actually make a lot of overseas investments and have a lot of overseas activities and operations. So in our client base, especially for the overseas investments, we do have a lot of SOE companies, clients. And we see that, you know, the organizational function as well as the cultural to compliance is quite different between the SOEs and the private companies. So if you are, I mean, lawyers who provide legal service for SOEs, you may, I would say, you may see quite some challenging and difficulties, because with respect to the application of laws and those provisions and rules, guidelines issued by the China competition authorities, basically they are the same. But within the SOEs, actually, they will have kind of a higher standard in terms of compliance, because there are several management or department within the SOEs. They will be responsible for those compliance issues and the risk management. For example, you may deal with the legal department, and you may deal with the risk controlling department, as well as kind of discipline department. At the same time, for one compliance program setting up and the implementations. But I would say, compared to the multinational companies and the private companies in China, I think the multinational companies, because due to the long developing history of their business operations, they may have kind of a smoother interaction mechanism within themselves to how to delegate functions and how to get the people in charge of the compliance programs. But for the Chinese SOE, so I would say they are still to try to find a more efficient way internally to how to say, to adapt a more efficient process for setting up the compliance program, as well as the implementation of the program. That's I would say the key challenging, both for the SOEs and for the external counsels who will provide legal service for them. I think in the old days, we have seen that normally the SOEs, they would not turn to the outside counsels to provide support for compliance program. But this has been, changed. We have seen a lot of, SOEs clients, especially when they have kind of material operations outside China. They are more and more companies will come to external counsels, especially for the international law firms to help them to try to build up the compliance program. Of course, antitrust is one of them, the most important, and even highlighted by the Chinese central government. So to set up the international compliance program and help them to smooth the internal flow chart to how to implement those programs. So our firm indeed, we have seen a lot of inquiries and also provided this kind of legal service and support to our SOEs. And in terms of private companies, they are more efficient because they are, I think they will be more quick and efficient to come to the decision maker level. They could be the move very quickly when you see when they deal with the external counsels and to internally align with their various the functions within the organization, covering the legal, compliance, and business team. So I would say for the SOEs, you may see quite challenging to how to help them to set up a very efficient or more smooth communication channel. But for the private companies, I think for the challenge is that you need to provide you support and the service very quickly and smoothly.
Thank you, Laura. And that is very interesting for us outside counsel to bear in mind that we have to keep considering the mindset of each type of company, whether it's SOE or it's a private sector, in order to help our clients to move forward in order to implement a very efficient compliance program. Thank you for that. And thank you, Michio.
Thank you, Angélica, and thank you, Laura and Michio. And so I would perhaps ask you now if you can comment on specific type of measures that you have seen have been implemented by the companies regarding compliance program, perhaps after an investigation. And if you can comment if such obligations include a periodic report and what has been the duration of the measures. So Laura, I'm going to start with you now.
Okay, thank you. In China, just in these 2 years, I would say it is very interesting that our competition authority, when they conducted an investigation, antitrust enforcement and antitrust investigations, they will not only to impose the penalties, the monitoring fines, but also they will order the business operators who are subject to these penalties to commit a competition compliance program. This is a mandatory requirement. This is a kind of obligation. And in some of the cases, it is important to know that for this compliance program and the measures being recalled, not only covering the antitrust, of course, antitrust competition compliance is the key requirement, but also, for example, data, privacy, and the consumer interest protection, etc. We have seen some cases while the authority required the companies to report the status of their compliance program implementation on a regularly basis in certain time period. For example, 3 years. I mean, forever, they need to report their compliance program on an annual basis to conduct, for example, self-risk assessment, or what we call the antitrust internal audit, to identify the risk, not only those have already been spotted by the competition authority, but some potential other that the behaviors, business models that may raise competition concerns, you need to identify and report to the authority and to consider, the risky mitigating measures. And you need to submit your proposal and to report to the authority and to get them not on the measures and the next steps. That's, I would say, a very interesting development in China, because we have never seen this kind of reform in the past 10 years.
That's certainly very, very interesting, Laura, and thank you for pointing out the details around that. What about Japan, Michio? Can you provide us some highlights about the specific measures that you have seen in compliance programs?
Well, likewise, compliance program and periodical reporting are considered important elements of remedial measures in case of formal enforcement, as well as in case of proactive plan of the alleged party in case of commitment procedure. What we typically see as concrete measures are introduction of compliance program, training to the employees based on such program, and internal audit by the legal department of the training and compliance situations, as well as the periodic reporting to the JFTC.
Thank you. So if I were to summarize, and you will correct me, but I understand that this will involve obligations related to reporting to the authorities, the activities, obligations to train the employees internally about the compliance program, including not only measures, as Laura was mentioning, on competition, but also reflected in terms of consumer protection where relevant, data protection also were relevant. And so what I'm seeing is that it is a very comprehensive approach that the authorities are taking as mitigating measures going forward, not necessarily as credits, but more as remedies, as Laura was qualifying them very rightfully so going forward. So I find this to be extremely interesting. Just to make you a final question, and thanking both of you very much for your time and your valuable comments. What do you think that would be relevant for Chinese and Japanese companies to understand about the application and enforcement trends in Latin America to do business and at the same time being compliant with competition laws, and how relevant do you think that would be for these companies? So this time I will start with Michio.
Okay, well, as you know, our competition law is now spread almost all over the world. So as long as the Japanese companies do business in Latin America, they should, of course, care about the competition laws in Latin American countries. Well, practical difficulties may be that if you are trying to cover the competition laws in every jurisdiction, it would be very costly, and the rules will be very, very long. So what we typically see is that we prepare the compliance program based on the most strict jurisdiction, which I believe should be the European Commission or the United States. In that manner, the Japanese company can have a robust competition law compliance program that fits with all or most of the competition laws in every jurisdiction.
That is very, very good to know, Michio. And I believe that, as you say, for a company trying to manage expectations from around the world, the right thing to do is try to achieve the highest standard in order to be able to comply with the requirements of most of the jurisdictions, if not all. So thank you for that comment. What about you, Laura? What would be your advice for companies that are engaging or are planning to engage in business in Latin America, Chinese companies? What do you think would be the approach they should take?
I think based on my own experience for those Chinese companies who, especially the SOEs who enter into Latin American markets, they are somehow aware of some local law requirements, but normally they will not, still, I would say a low awareness of the local antitrust law requirements. So that's something when I talk to my clients, I will normally to remind them that although the principles or the basic requirements will be the same for a lot of jurisdictions, but you need to understand the local requirement. So currently, I think the SOEs, the first step they have made is that they have kind of international compliance program or international antitrust guidelines covering some basic requirements, for example, the merger controls and the behaviors, cartel, vertical restraints, etc. But when the second steps, I would say they need to localize those guidelines, not only to have something just a handbook, and actually the local business team may not even to read them. I would say they need to emphasize that the routine trainings and the localized training will be quite important. That's something we are currently working with some Chinese SME clients to try to persuade them. You need to understand the local law requirements, and especially I would say in this my limited knowledge, I would say that the Latin American competition law in some circumstances might be different from the Chinese rules and the EU rules, especially the merger control requirements and some behaviors requirements. They might not only focusing on pure competition, but also consumer protection, etc. So that's that I would say you need to, yes, you need to understand some basic rules, but also a deep understanding and the awareness of the local law requirements, and have your local business team to actually be trained and understand the local requirement. That will be the key.
That's very, very, very interesting, Laura. Thank you very much. So Carlos, I think that Michio and Laura have given us a very clear overview and very good insights about the trends in these very important jurisdictions, and also have given us very insightful comments about how they would advise the companies in these jurisdictions. So what I take from their comments to my last question is that, first of all, aim for the highest standard. That will always should always keep you safe. So aiming to comply with international standards is a good practice. But then also, as Laura was mentioning, trying to understand the local requirements is also important. Most and foremost, when you are aiming to do business in jurisdictions that are somehow foreign to you, although the world is very connected. And as they were both mentioning, the standards are increasingly standardized, if that is not a contradiction. But thank you, Laura and Michio. And back to you, Carlos. Thank you.
Well, thank you very much. This was great, like great questions, and all your responses were actually very clear and very insightful. Thank you very much. This is very interesting. I would like to conclude this with hearing from Carolina, and maybe we already discussed Michio's and Laura's point of view from those far away jurisdictions, far away from our standpoint. I would like to know what will be your recommendations for Colombian and Latin American lawyers in this? That we're very familiar with United States and European competition law, and of course our systems are built up on with those influence. But being Japanese and Chinese companies, of course, more prominent. Of course, the competition law is also getting a real relevance these days. Do we have to rewire something? Do we have to understand something different? What will be the difference, if you can highlight, if there's any, that you will say, okay, the main difference is this one, and what will be your general recommendations for Colombian and Latin American lawyers when advising companies from Japan and China, specifically in these compliance programs, design and implementation?
Thank you, Carlos. Well, I will talk about my experience, and I think that one important aspect that I have found working with my colleagues in China, my colleagues in Japan, and in Asia Pacific in general, is that gratefully we see that in terms of competition laws, the standards are very much alike. The principles are very similar. Having said that, I believe that it is very important that you do discuss upfront with the companies and the practitioners within the companies that you are going to represent about, first of all, what is their experience? Second, what is their knowledge about the laws in the region? I think both Michio and Lara were talking that it's always challenging to do business cross-border because you are really walking in a territory where you don't really know what to expect normally. So first of all, informing yourself on the expectations of the company, the level of understanding of the company, of the laws of the jurisdiction where you are practicing is important. And I would tell you that making assumptions is always a big risk. In my experience, assuming that the person across the phone, across the video conference, or the person that is wanting to do business is talking the same competition language is something that you would like to confirm and verify. Second, as Laura and Michio were expressing, the different approaches from the different types of companies is something you also need to understand. The industries in which they operate, the size of the company that you are advising, and the type of activity they want to perform in the region is something that is always good to know and a good starting point for the conversation. Once you have clear many of these things, it is, I think, easier to set out the standards and the action plan on the advice you want to give. I think that something that we learn early in school is that making questions at the beginning, if you're shy, you feel that you may be looking not so smart. But I think that the best advice I can give my colleagues is never be too shy to ask all the questions, because it's through the questions that you actually get awareness of where you're standing and what your client and the company wants to do.
Thank you. This is great. So let me just summarize what you said, if I understood correctly. So the standards are pretty much the same, are pretty much alike. So the main message there is that no need to panic. So if you get this consultation, well, you know the basics, but it's really important to confirm that you are talking the same language to people. And that's why it's very, very important to ask those questions. And you frame it as there is no need to be too shy. I will also say there is no need to be too smart. You always have to ask the question. You don't know the answers of everything. And of course, adapt to the type of activity and type of company that you are representing. That will be your main consideration for this. This is great. And this was the last question that we have. So I think unless someone else, Michio, Laura, Angélica, or even Carolina wants to say something before, I think this is all for now. And thank you very much for all your help and participation in this program.
No, not at all, Carlos. I think it's our pleasure. And I would only like to add that the devil is in the details. So be mindful about the details, be mindful about getting the big picture, but also be very specific about the details of compliance, because that's where things can go wrong. I want to thank you all and thank you for the invitation. I think it was a pleasure for all of us to be here, for Baker McKenzie to be invited to this conversation. And also thank you, Michio, Laura, and Angélica for joining us.
Thank you.
Thank you.
Thank you. Bye.
Bye.
Thank you very much, and see you all in our next interview. Thank you.
Sure. Thank you.